Donald Trump and his defense team are not happy. They want access to the case files, the discovery that they need, and they say Jack Smith is not giving it to them. And so we've got a new motion to compel, except this one is coming out of Florida. This is the classified documents case. We've got a 12-pager here. We always like when we have some substance to unpack. But of course, the case is United States of America versus Donald Trump, something we've covered a lot here. This one out of the Southern District of Florida. Judge Eileen Cannon is presiding. And we've had some battles here about CIPA and the Classified Information Procedures Act and about the documents that Jack Smith has that Donald Trump says he needs to review before they can prepare their defense. How can you prepare your defense if you don't know what the evidence is? And so they don't have access to that evidence, and so they say we need a revised schedule. We know we're scheduled for trial pretty soon, but we need more time so we can review the evidence. And this is the motion to compel. Jack Smith and the special counsel's office has not been complying with their requests, and so they're asking the judge to step in here. So this is signed by Trump's defense team. They tell us here now, President Donald Trump respectfully submits this memo in support of his pending motion for a revised schedule, for motions to compel, and for CIPA litigation. So we need some new deadlines, and we need an adjournment of the trial date. So just take the current trial date, delete it, and postpone it until at least mid-November 2024. Isn't that interesting? Is there something else happening in 2024 in November? Oh yeah, the presidential election. So they say in light of additional ongoing discovery failures by Jack Smith and the special counsel's office. So, Your Honor, they're not complying with what they're supposed to do. They're the government. They have to give us the evidence in order for us to prepare our defense. Since they're not doing it, we need more time. And we're also going to need more time for our motion to compel deadline. So here on July 18th, they give us an update. They say Jack Smith's office told the court, you, Judge Cannon, they told you that all discovery would be available on, quote, day one. And they reference the transcript saying it's right here, July 18th, 2023, transcript, line 62. They said it, not us. Following the court's July 21st scheduling order, the same office, Jack Smith, demanded a conflicting schedule in another case, which was United States of America versus Donald Trump. That was in D.C. So we've got a March 4th trial date out of D.C. That is the January 6th case. And the underlying schedule in that case, both of those currently require Trump and his lawyers to be two places at once. So Jack Smith is obviously in both of those cases, so out of Washington, D.C. and out of Florida. And so he is asking for simultaneous dates. Kind of ridiculous. He should know better than that. And months after special counsel, after they told you that, Your Honor, discovery is still not complete in this case. They said it'd be available on day one, but we don't have it today. Including with respect to the classified documents at issue in more than 25% of the court counts in the superseding indictment. Not complete, including with respect to at least with respect to the classified documents at issue in more than 25% of the counts in the indictment. So there's a lot of noncompliance. The ongoing noncompliance cannot be written off as a series of brief delays or slightly longer than anticipated time frame. They're saying that Jack Smith was responding to this, oh, Your Honor, it was just like a brief delay. Just taking us a slightly longer, but we'll have it to you, at some point. They say, nevertheless, Your Honor, okay, Jack Smith and his team, clinging to an unprecedented and now an untenable trial date, the office presses the court to continue with the accelerated schedule. Jack Smith wants you to continue to go fast, even though the prosecutors have not followed and in all likelihood are not going to follow the rules. So we're going to have multiple rounds of CIPA litigation. Okay, we're going to fight over disclosure. Jack Smith is going to say, I've got document A, B, and C, but you can't see those. And Trump's going to say, I need to see them. And the judge is going to have to get involved to settle it. So if you have a bunch of those, round and around we go, how can you have a trial in May of next year? The demands of the special counsel's office must give way to the constitutional rights of the defendants, meaning Trump, and the interest of the judicial economy. So therefore, Trump respectfully requests the court adopt his proposed revised schedule for the various motions and schedule the trial to begin at a date convenient to the court in or after mid-November 2024, after the election, and set further deadlines so we can hash through all of this stuff. They say, Your Honor, This is warranted. The court has already admonished, kind of scolded, the special counsel's office for failing to establish the appropriate facilities before even bringing this case. And they reference back to the docket. They say, the court, Your Honor, Judge Cannon, you were correct. Brilliant. We love your decision. There are now additional problems relating to this issue based on what we've seen. The office's special counsel, Jack Smith, their failure to timely remedy the situation is alone a basis for granting the requested adjournments. And they've got some footnotes here for us. They say, indeed, the office's delay has compounded the scheduling challenges that was previously identified. They say one of Trump's lawyers, Mr. Keese, is not fully cleared to even review these things. And he's got another trial scheduled in New York, which is expected to conclude by December of this year, 2023. So he's had no opportunity. They say Trump's lawyers are split all over the place. So Mr. Keese, Trump's defense counsel, has had no opportunity to review any of the materials for CIPA, and Trump should not be denied assistance of counsel because the government is delaying the discovery process. So Trump is, they're setting up right now an ineffective assistance of counsel claim. So when Trump loses, ineffective assistance sometimes will mean your lawyer is a bonehead, right? They kind of goof something up, they missed a deadline, or they totally botched a case in some really critical way. So we're not going to prejudice the defendant. If your lawyer screws up, it's not like, oh, sorry, you can go to prison for 40 years because your lawyer's an idiot. If your lawyer did something very, very bad, then you might, get a second crack at that issue, get a new lawyer, and have ineffective assistance of counsel, so the whole thing gets done again. But it's a complicated thing, right? Your lawyer really has to screw up. Or the court denies your attorney the ability to do their job. And so in this case, the example would be, well, not in this particular case, this is Florida, but in another case in D.C., Judge Chutkan has basically ordered Trump and his defense team to review 8 to 10 Washington Monuments stacked tall worth of copy paper of discovery in a very short period of time between the trial date scheduled in March of Washington, D.C. So that's virtually impossible. Okay, it is impossible. And we've read through the motions there. They said it's like reading War and Peace 95 times every day for 7 days a week or whatever. So it's basically nuts, right? Trump would have to create a whole team of readers to just read through the discovery, right? Discovery processors, and it's totally impractical. The government has unlimited funding, but the defense does not. There's just not enough time for all the lawyers to read all the discovery because you can't split it up and just say, well, how about you read pages 1 to 10, you read 10 to 20. It's like, no, everybody's got to read everything so we all know the case. So the point is, that is, in my opinion, the court creating an environment where the lawyer, the defense team, is ineffective just by virtue of the fact that they can't read all the documents. So here, Trump is they're laying the foundation for that. His defense team is sort of saying to Judge Cannon, in this case, the Florida judge, that look, if we don't have access to 25% of the materials, that's a fourth of the case. We can't see what is inside. We will be ineffective unless we get more time, or unless we get you to compel them to give us the documents. They say co-defendants here, the other two co-defendants in the Florida cases, Walt Nada and De Oliveira, are also joining in on this. They are noting that the special counsel, Jack Smith, of course, objects to all of this, but Trump wants to be heard on it, so they want this to have oral argument so we can go and hear about it. They say, we understand that it will be more than 3 months before a secure facility is established in the Northern Division. So Jack Smith needs to establish some place for the defense to review the documents, and it's going to be another 3 months before they even prepare that. Well, why is that Trump's fault? The burden is on the government to bring the prosecution. He's got a right to a speedy trial, but if he can't get access to the documents to review them in time for a speedy trial, then his right to a speedy trial is kind of being usurped, is it not? Because the court can come in and, well, no, we'll just need to build another facility, and our contractor is delayed again. It's always a difficult job to get the electrician out here. And so they can just delay. That is not the defendant's responsibility. It's innocent until proven guilty. So while the special counsel's office urges the court to accept this filing in less than a week, it does not appear that there's even a place for the court to maintain that submission in its custody. So in this case, submitting stuff to the court. So in the court facility, they can review the documents. So the court, even as a practical matter, can't even receive the documents for some time. Even more problematic, we understand the court currently lacks access in the Northern Division to electronic facilities necessary to write opinions and orders related to classified information. So not only can Trump and his defense team not see any of this, but neither can the judge. And two, they say physical space to conduct any hearings related to this, so you don't have Putin creeping around under the rafters somewhere in the courtroom. Say that here, you got to create a secure facility to even have oral arguments about this stuff. So copies of the classified discovery have not been transported to the Miramar facility. This is Trump's defense team, which we also understand has also not yet been approved for review in the storage of that classified discovery either. This, along with the fact that Trump's defense only has access to a small temporary facility in Miami, that has delayed Trump's personal review of the classified discovery under the procedures that the court approved on September 12, 2023. They say Jack Smith's office also waited until the day after filing its opposition submission to notify Trump that, quote, the owners of the documents at issue had required those documents to be removed. So they're being sneaky with some filing dates. Like they notify the court, oh, hey, this is the current status of things. And then the day after they file, they change the status of everything. Like, oh, sorry. But what they told the court was true at the time. We have not yet been provided with an estimate of when those materials will be returned. So they tell the court documents are here, but then they move the documents, and then they say, we don't know where the documents are. So you show up, and you're like, oh, well, you said yesterday. I'm like, oh, that's always yesterday. Sorry. While the office has offered to make those documents available in Washington, D.C., so they move them out of Miami, so you have to go to D.C. to look at them, the logistics of the arrangement are unworkable because the other classified documents and discovery is in this district. So why'd they remove it out? The documents at issue must be reviewed in conjunction with those additional materials, and we have no way of transporting classified notes and other work product back and forth. You put the restrictions on us, so we can't go to D.C. and then bring it back to Florida. So this is prejudicing President Trump and this is resulting from the current arrangement, which is exacerbated, as far as we know, by the office's lawyers, investigators, and they face none of these issues. Okay, so Jack Smith, they can just walk across the hall, walk right into the room. Oh, what's going on here? I want to look at document 5, folder B, whatever. In sum, the special counsel's office has failed to make the very basic arrangements in this district for handling the classified information, stuff they're required to do under the law. That's why we need time to make adjustments for these facilities even to be established. Now, Trump's defense continues. They say, in addition, Your Honor, in part 2, Jack Smith's office did not address in his prior motions or even defend its representations to the court that it made. They told you in June and July, they told you, Your Honor, that it was prepared to produce, quote, all discovery, quote, from day one, quote, including all witness statements. They told you that. That's why you set those deadlines. But those representations were the fundamental premise for this current schedule. And they were not inaccurate, is what they said. Therefore, the adjournment should be granted. Oh, they were not accurate, okay? Those representations are exactly why you set the schedule, because they promised you they were ready from day one, but they were not honest, Judge. For that basis alone, you should move the dates. They say unclassified discovery was not produced on, quote, day one. Jack Smith talks like he's in compliance, but he's actually not. Since the court's July 21st scheduling order, and notwithstanding the day one representation from Jack Smith, the office further complicated the case by charging a third defendant and producing another 23% more unclassified discovery. So Jack Smith came in, he had two co-defendants, said, we're ready, let's get to trial very fast, we're ready to go, Your Honor, America needs justice, blah, blah, blah. Then indicted someone else the next day. And guess what that does? It adds a whole another component to the case. Like it's kind of a new case because you've now got another person who might be pressured to testify or might be useful to the defense. It's a mess. So Jack Smith was not being totally honest when he said we're ready on day one because everything changed the very following day. Specifically, by the time of the order, the office had made two productions consisting of about 550,000 records in excess of 1.1 million pages. Oh, gosh. That's a lot of reading. With approximately 236,740 emails. Almost 250,000 emails. More than 313,000 documents from 96 separate custodians. 2 productions full of this. 57 terabytes of CCTV footage. And since the scheduling order, they've produced, since Your Honor, scheduled the dates for us, we got even more. Produced another 131,000 records, another 166,000 pages, 1,300 emails, 130,000 additional documents, and 19 terabytes of CCTV footage. The court observed in the scheduling order, you said, Your Honor, yourself, that the discovery in this case is exceedingly voluminous, and it will require substantial time to review and digest all of this in accordance with Trump's right to a fair trial. So, in light of all this discovery, you're right, Your Honor. It is voluminous. Okay, we didn't know exactly what it was going to be at the time, but we know now, and it is not good. And so President Trump requests more time to review these materials. They say all witness statements, remember when they told you this, Judge, all, quote, that they have not been produced promptly? Let me give you some meat on that one. They say the office from Jack Smith fails to acknowledge its written representations to the court. As early as June, they said it would, quote, promptly produce all witness statements, even if they would not be deemed discoverable. The office now declares that it will produce, quote, agent communications that are Jenks Act material for testifying agents at an unspecified later date. That's interesting. Isn't that interesting? It went from promptly and all to later and just certain materials that are relevant to the defense. So like just different things that the witnesses rely on. So it's not all. It's just very narrow things that might be relevant to the defense based on some prosecutor. A small volume of classified materials, primarily agent emails, again without explaining it when it will do so. And while we're aware of the deadlines imposed by the Jenks Act, the office itself agreed to much earlier productions and urging the court to set the accelerated schedule. Right? So it went from this very broad delivery to reining it in, and from being very fast to being very slow and undefined. And so, Your Honor, you gave us the schedule based upon their promises. Their promises have changed. More than 25% of the charged documents and additional classified discovery is still outstanding. So over 1/4 of the whole case we haven't even looked at. 9 of the documents charged in the 32 pending counts, as well as several uncharged documents, are not available here in Florida. As we understand it, documents relating to counts 6, 22, 26, and 30 have all been moved. Okay, so they took 4 counts, and the evidence related to those 4 counts, they just moved it over to D.C. at the request of the documents' quote owners, whoever that happens to be. The documents related to counts 5, 9, 17, 20, and 29 are not available to Trump or counsel at any location. Okay, wow. So this reeks of like evidence destruction. Who took these documents back? Who are the owners? Is it going to be the National Archives? Is it going to be the White House? And really, is it the White House exercising ownership via the National Archives, right? Is Biden declaring, oh, those are Iran war plans, and so I want those documents. I need those documents now as a matter of national security. So the president picks evidence up and takes it out of the field as a matter of national security. The documents are just gone. Now, probably nothing to do with national security at all. In fact, those documents might be exonerative, right? Those documents might prove Trump is innocent, or they might be showing that, no, it's not actually nuclear secrets, okay? It's actually Milley's war plan to go and invade Iran or whatever. It's not mine. I took it to exonerate my side of the story when history is written, and I have the right to do that because I'm the president, and I can declassify things by virtue of the fact that I'm the only one who has the opinion power in the United States Constitution. So you can reverse engineer that, but who is now pulling those documents out, trying to take them off the board so that Trump doesn't have access to them? And there looks like pretty significant documents. Who are the owners? So they say the document relating to count 19 was made available to Trump for the first time in the late afternoon of October 3rd, only after Trump's lawyers left the district following 2 days of review at the temporary Miami SCIF. Jack Smith also has previewed an additional classified production. He said by October 6th of certain materials that Trump and the other defendants have described as outstanding, including information related to the classification reviews. So very broad, very vague. We don't really know what is coming. So despite all of this, the special counsel's office seems pleased, Your Honor, to report back to you that it has produced, quote, the majority. They're very, hey, we did a great job. And we know who works on these cases, Molly Gaston and others. And they're very, enthusiastic about their work product, highlights and sticky notes and so on. And they say that they've done a majority that it anticipates producing. And you're like, what does that even mean? We don't. What do you have to anticipate? You said it exists. Give it to us. There is nothing to anticipate, and the majority is not good enough. We want it all because we can't begin doing really anything until we get it all. Because you could review everything and say, wow, this is a great case. Perfect. I know exactly what our strategy is. We have our theme. We have our opening statement. And they release you that 1%. And you're like, oh, isn't that interesting? I can see why you delayed so long to give us that piece of evidence because it's really damning for your case. Isn't that convenient? And so now you get that evidence and now the whole structure of the case changes. Now everything shifts, right? Or maybe, if this is not a national political prosecution brought by a weaponized Democratic Party against their political opponents. In another case, right, that would where you'd get a good plea deal or something, and you could close the case out. But here, anticipates producing. Maybe they'll wake up one morning and just anticipate differently. Well, we decided they don't need that today. No. This is a marked departure from the office's representations to the court months ago, and there is cause for concern that the office, quotes, anticipates producing is less than what it's obligated to produce. In this regard, we note that the as of yet unproduced classification reviews are obviously discoverable, meaning we can get access to that. And the office told the court in July that all the documents had already been through that process. But now, Jack Smith only agreed to produce these materials after Trump raised the issue. So he said it was available, then didn't give it to us, and then maybe that's because they didn't anticipate giving it to us, but then we demanded it, so now they're going to give it to us. I'm like, wait a minute. You've got the duty to disclose your evidence. Give it to the defense. They say, Your Honor, these are not mere complaints. Jack Smith's office has not provided some of the most basic discovery in the case. And given the current schedule, we, Trump's defense team, cannot understate the prejudice to President Trump arising from his lack of access to these critical materials months after they should have been produced. It's exceedingly difficult to meaningfully review portions of the classified interviews stored in the temporary Miami SCIF that relate to documents that are not located in the district. They moved the other half of the pie to the other district. Moreover, our discovery requests to the office will be document specific, and we cannot move forward with that process until we have all of the materials and access to a computer that we can use to write to them and to the office and to the court. And we lack secure facilities to handle the evidence. Jack Smith seems to disclaim responsibility. He just says, well, you don't have a place to look at it. You go, well, you're the one who brought the case. So you bring a classified documents charge and the defense has to go build a government facility to review them in? The office points to no instance in which we have delayed a required read-in that was made available to us because that's not happened. Okay, we're not missing any of our deadlines. They say be here to get your certification, we're there. They say show up, do that, we're there. But their documents are not there. The office is responsible for complying, meaning Jack Smith, for complying with its discovery obligations, including navigating restrictions and concerns from the, quote, owners, whoever that happens to be, and equity holders of the relevant materials so that Jack Smith's office so proudly identified in the superseding indictment. It is not at all irregular for these types of issues to arise in a case like this, Your Honor. What is irregular is Jack Smith's schedule. Why are they trying to hustle this thing through so quickly? Even when it's failing to make appropriate arrangements on the timeline it demanded. They wanted to go fast. They said it was all available. We said, okay, I guess we're going fast. Give us it all. And then they said, no, you don't get it all. So the court should require disclosures regarding any PSRs. They say in response to Trump's concern that the current schedule is unworkable, they say because of the need for further discovery, and they're saying that there is going to be a problem with these things called prudential search requests, PSRs. There's going to be litigation about that. And they say it would have been very simple for Jack Smith to explain, if true, that it had completed all PSRs and incorporated the findings into the office's plans for classified discovery and CIPA practice. And so this is where they go and they talk to all of the other government agencies. So remember that the government has a duty to go make sure that if they have exculpatory evidence against the defense, that the defense knows that, right? If they have an officer who they know lied about your blood test, or they have an officer who they know planted evidence or something, these are, basic cases. They've got a duty to disclose that to you. And if they don't disclose that, and you find out about that, your case gets dismissed. And even if that happens, later down the road, it opens up a whole can of worms, petition for post-conviction relief and all these things. So what they're asking for here is, when we're talking about the classified materials and Trump's making requests, the government is very separated, kind of siloed off a bit. So these search requests are to go and try to connect to the other bureaucracies to see where there might be evidence that is related to this case. Think of it like a web crawler going out, searching all of the government, coming back, saying, hey, we searched for these things, we didn't find this, and just so you know, we've done our due diligence. So the question is, did they do that or not? Would have been very simple for them to just say, yes, we did. The office suggests that they have, but fails to confirm, and they say that they've distinguished other cases with notable vagueness. They say Jack Smith conceded that, he said, well, PSRs, these prudential searches, they're sometimes conducted in national security cases, but maybe not all the time. So did he do them or not? And acknowledged that prosecutors typically do this before charges are filed. Typically. Okay, well, did you or not in this case right now? The office failed to explain whether and to what extent it conducted PSRs in this case. These are material omissions that must be addressed before we resolve this motion. And here they say, Your Honor, look, it's pretty clear, all right? Trump has identified the Justice Manual provisions that require PSRs and example cases where they're supposed to do these searches. If special counsel Jack Smith, if they've declined to collect and review the U.S. intelligence community's holdings, right, all of the various agencies, if they've declined to collect and review those, it should be required to make that clear on the record. Don't tell us typically or whatever. If you didn't do those searches, let us know. In light of the frequency in which these searches are conducted in cases around the country, the failure to conduct them here would itself be discoverable. Okay, we would be able to know that. Did you do it or not? It would implicate Trump's due process rights. Why didn't they do it? And serve as evidence that the prosecution has intent that is focused on selective prosecution. They say Trump is going to be filing one of those. And if we find that they didn't do this very basic step of these PSRs, these prudential searches, to go investigate whether there's other evidence, the question is why. There's a pattern of doing that in other cases like this, but not in this one. That's because this is selective prosecution, and we're going to make that point later. Your Honor, also, Jack Smith is wrong because he says that PSRs are, quote, not legally required under the circumstances of this case. But some of the documents at issue here in this case address topics that are covered in open source materials. They say it is extremely likely that at least some USIC, the intelligence community holdings, undercut Jack Smith's contentions that documents related back to earlier contain information that was closely held at the time. They say as a result, the office, Jack Smith, is on notice, they know about it, that there is potentially exculpatory information held by the same, quote, owners that it acknowledges, and that they have a constitutional duty under Brady to collect and produce those materials. Accordingly, the court should require the office to disclose whether they did the PSRs, the nature of it, and what was inside. They say, Your Honor, Jack Smith is objecting to Trump's request to compel this litigation. He wants to ask the judge to order them to disclose these materials. Jack Smith obviously objects to that. They say his office is misinterpreting a case. In another case, they interpreted it one way, but that's the inappropriate way to do it. Speaking for the entire government, they say Jack Smith asserts it's not aware of any case that requires them to do this thing. And they say that's pretty surprising because they've seen several cases where they've done exactly that. They say we don't have to file a responsive briefing, and Trump's defense is saying, that's curious because we did a search on this and we found a bunch of other instances where you've done exactly that. Here's one case, United States versus Alcala Cordones. Another one, CIPA case. Here's another one, Ali Ahmedi. All did this exactly. So they say the special counsel office is mischaracterizing the other case law. No authority requires what they say. Trump is going to argue at the appropriate time under the unique circumstances of this case that these extra ex parte proceedings, these side conversations, are not only not necessary, but they're being done according to the inappropriate standards. So we'll see more on that later. And they say here, Jack Smith's office is explaining other cases that are just not relevant to the current issues at hand. The approach that they want to pursue is entirely unwarranted. Fact is, they have not disclosed to Trump all the materials to which he is entitled in a case that is destined for additional untimely disclosures in light of the fact that they did not even include the classification reviews in its initial productions. They're not even giving us the basic stuff, Your Honor. So, with all that said, Trump's lawyer, Christopher Key, says there is no good reason to continue on the current path. Therefore, President Trump submits that the adjournment requests should be granted. And that request, of course, postponing this trial all the way to the middle of November. And middle of November, right after the election, which I think is a more appropriate time to have any trial in any one of the Trump cases, because of course he is a presidential candidate running against Joe Biden. It feels a little bit strange to have multiple trials of your political enemy in the middle of an election year, but that's their point. That's how we know it is a weaponized prosecution. They waited multiple years. They brought 4 of them all at the same time, and there may be even more coming. We will see. But Trump is filing this motion to compel. We'll see what Judge Cannon does. She's a little bit more of a neutral judge relative to Judge Chutkan, who we've seen a lot from in the Washington, D.C. case. But there will be a ruling on this. We'll see if the trial date moves, and this will not be the first attempt at a trial date adjournment or a postponement, a continuance. I think we'll see a lot more of them because these cases are complex. They are new and novel, and they're not going to be settled quickly. Now, what does Cannon do? Does she postpone it? I am more inclined to believe that she does. Judge Chutkan in Washington, D.C., I still don't think that's happening. She wants that trial to happen in March, the day before Super Tuesday, so that it has the necessary impact. But Trump's team putting up a great fight. I really enjoy reading their motions because I think that they articulate clearly all of the burdens that Jack Smith is putting upon them and all of the double standards that we see in his practice. Trump needs to go very fast, but other cases can go long. He says we got everything on day one. Really doesn't have much of anything. So we'll see what Judge Cannon does about it, my friends. Of course, we'll be here continuing to cover this case and many more. Hopefully you join us and hit that subscribe button. Thank you for hitting that like button as well. We'll be back here on the next one to dig into it again. We'll look forward to seeing you there. Make it a great day, my friends. Bye-bye.